Kung mahusay ang pagkalap at pagsisinop ng ebidensya, lumalaki ang tiyansang malutas ang anumang krimeng sinisiyasan. Kaya sa mga kasong aming tinututukan, aming kamera, dadalhin kayo ng inyong Group 3 Soko sa sentro ng investigasyon. Bawat hakbang ng mga crime scene investigators ay aming susubaybayan hanggang sa aming pagpupusigi sa paghanap ng katotohanan gamit ang siyensya, logika at ang pagkamaparaan ay humantong sa pagkalutas ng kasong aming tinututukan. Humanda na sa misteryo, drama at totohanang pagsisiyasa. Hatid sa inyo ng Group 3. Scene of the Crime Operatives. Hapon, noong ika-20 ng Pebrero taong 2005, maagang umuwi sa kanyang bahay si Attorney Generoso para doon ipagpatuloy ang kanyang trabaho. Sakto naman na sa mga panahong iyon ay masayang nag-iinuman ang kanyang mga kapitbahay. Sa pagdating niya ay nadaanan niya ang kanyang mga kapitbahay na masaya noong nag-iinuman.
Oh, masisaba na po mo niya ha. Trabaho ba ako sa taas?
Ngunit dahil sa kanyang sinabi, minasama pala ito ang kanyang mga kapitbahay na sina Joey M. Pestilos, Dwight Macapanas, Miguel Cases, Jerry Fernandez at Ronald Munoz na nag-iinuman habang sa panahong iyon. Nang dahil sa kalasingan at sama ng loob, pinangunahan ni Joey Pestilos ang pagsugod sa bahay ng naturang abogado para lang dapat sana ay siya ay kumprontahin. Habang nagkakagulo, narinig ito ng iba pa nilang kapitbahay na maglalabas sana. Ayon sa saksi na si Marites,
Ojo ko naman sa mga ganina. Anak pa ko, mauman ko na kung labunon, makalaang ko ilang madstick ya. Nakadugan na kayo. Kita niyo madstick ya. Uy, chika-chika ba? Yan ako, hindi nyo na sa tinatano. Nang nag-away. Ano ba? Ano to? Nikat-kat ko sa mga padir. Langan kung naunsa na ba sila mo to kung ditanaw. Sus, pagkakita na ko. Uy, sa Attorney Rene, nagkadugo, uy. Uy, lagi kayo, nagkadugo. Tak pala lagi ka na.
Hello ma'am, sir. May buntag. Si ano ma'am? Ma'am, may buntag. Attorney Moreno ma'am. Yes ma'am. Si ano ma'am? Hello sir.
ayon sa suspect.
Sir, para sa kundi sir. Nalungkaban lang po sir. Dali sa among balay, sulod sa among balay sir.
Sige ma'am. Sabi niyo si ma'am, no? Sige ma'am, inform lang mo si Upi ma'am para ma-discuss na ng tao niya. Okay ma'am.
Ulat ko sa inyo, sir. Sir.
At agad namang pinuntahan ng mga pulis ang mga naturang suspect para lang sana imbitahan sa presento at ibigay ang kanilang salaysay base sa akusasyon ng naturang abogado.
Ayo.
Buntag.
Buntag, sir. Buntag, sir.
Sir, mo ano yung balay ni Joey Pistelos?
Kilos? Ako. Pwede ba ka maimbita na mo, sir, sa estasyon?
Ano sa may sala na kung ano?
Alay, nagreklamo dito. Sige lang, dito na lang ito baga, sir.
Biyan sa trabaho, sir.
Matapos na maimbitahan ang mga magbabarkada, kahit may iniinda, nagtungo ang naturang abogado sa presento para personal na patutuhanan ang kanyang mga bintang sa mga nananakit sa kanya.
Sir, ako si Joey Pistelos. Sir, katong nga time ang lingaw-lingaw raman mi ato, sir. Siya sayaw raman kanta-kanta, sir. Baon niya, kanisa, di kalit raman magsumbag, sir. Nisiyagit pa, nisiyagit siya sa mua. Kani mga kauban mo na ako, sir. Ipinsa rapod. Ipinsa rapod na ito mo, sir. Hindi wala man may nagpatama sa iya, sir.
Tawag, sir. Ay, maluhay ka.
Dali lang, ha. Matutong sa attorney. Matutong sa attorney.
Uy, nandito na sa mga bulyo.
Matutong sa attorney.
Uy, attorney, may buntag. Nalari atong nagdunggab sa imo, ipakonfirm na unta kung mo ba ni sila. Attorney mo, ning nagdunggab sa imo ha, o nagsumbag.
O, kani sila tulong.
Kamo gidakop namo sa krimen nga pagpanunggab o pagpangulata. Angay mo makabalong nga dunang mo'y katungod sa pagpahilo. Ang inyong mga nasabtan ba ninyo inyong mga katungod?
Base sa salaysay ng biktima, kinasuhan at nahatulan ang mga sospek. Subalit giit nila ay naimbitahan lang sila sa istasyon ng pulis. Kaya ang inquest proceeding ay hindi wasto at ang isang regular na pamamaraan para sa paunang pagsisiyasat ay dapat na ginawa alinsunod sa Rule 112 ng Rules of Court.
Contrary to law, on March 7, 2005, the petitioners filed an urgent motion for regular preliminary investigation on the ground that they had not been lawfully arrested. They alleged that no valid warrantless arrest took place since the police officers had no personal knowledge that they were the perpetrators of the crime. They also claimed that they were just invited to the police station. Thus, the inquest proceeding was improper, and a regular procedure for preliminary investigation should have been performed pursuant to the Rule 112 of the Rules of Court. The petitioners also claim that no valid warrantless arrest took place under the terms of Rule 112, Section 7 of the Revised Rules of Court. The incident happened 2 hours before the police officers actually arrived at the crime scene. The police officers could not have undertaken a valid warrantless arrest as they had no personal knowledge that the petitioners were the authors of the crime. Preliminary investigation is an inquiry or proceeding to determine whether there exists sufficient ground to engender a well-founded belief that a crime has been committed and that the respondent is probably guilty thereof and should be held for trial. When accused lawfully arrested without a warrant. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Before the complaint or information is filed, the person arrested may ask for a preliminary investigation in accordance with this rule, but he must sign a waiver of the provision of Article 1 through 5 of the Revised Penal Code as amended in the presence of his counsel. Notwithstanding the waiver, he may apply for bail, and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in court, without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule.
Depensa naman ng isa sa mga suspect.
Mayong gabi sa inyong tanan. Ako din si Dwight Macapanyas o na ako karon para magbutyag kung saan tinuod nga nahitabo anang gabi una na nagasumpaki ang among grupo ug si Atty. Moreno. Gusto po na ako malimpyo ang akong pangalan. Kay sakit kaayo sa akong buot nga ako maginikanan wa gyud ko badak ang bayulintik ug salbahis nga pagkatao. So ang among istorya ana pagkagabi kini si Atty. Moreno nikalit tagduol sa amo, peaceful kayo niya, wala gyud ni gibuhat, lingaw pa mga kayo mi, shot sayaw kani si Atty. Moreno nikalit man siya duol tapos bikil ni. Wala mo siya pansinan, sagdan lang namo. Action man siya kabayulente noon. Moto, mo sa kauban kitang paros siya. Nya kami tabangan namo kay proteksyonan namang kaugalingon. Action man siya kabayulente gud. So moto kami di na mo ikalimod nga part gyud ni atong pagkulata kang attorney. Pero tungod dito kay among giproteksyonan namong kaugalingon kay kun dili kami may maalanganin. So, attorney, ikaw ang nag-una-una attorney, dili kami. Amo ra giproteksyonan ang kaugalingon. So, mao gani ito pagadto sa mga pulis. Duol mi sa mga pulis. Invite daw mi nila sa istasyon. Uban mi kay so may mukadlukan nga tama man ang gibuhat kamo daw nga tuon. So, wala gid kun hadlok na ni adto. Basta ikaw attorney, imo ming giunhan ug among giproteksyonan mo kaugalingon.
Kaya inakyat ng grupo ni na Joey M. Castillos ang petisyon sa Court of Appeals at ayon sa desisyon ng Court of Appeals.
The Court of Appeals decision. On January 21, 2008, the Court of Appeals issued its decision dismissing the petition for lack of merit. The Court of Appeals ruled that the word invited in the affidavit of arrest executed by SPO2 Javier carried the meaning of a command. The arresting officers clearly meant to arrest the petitioners to answer for the mauling of Attorney Generoso. The Court of Appeals also recognized that the arrest was pursuant to a valid warrantless arrest so that an inquest proceeding was called for as a consequence. Thus, the RTC did not commit any grave abuse of discretion in denying the urgent motion for regular preliminary investigation. The Court of Appeals saw no merit in the petitioner's argument that the order denying the urgent motion for regular preliminary investigation is void for failure to clearly state that the fact and the law upon which it was based, pursuant to Rule 16 of Section 3 of the Revised Rules of Court. The Court of Appeals found that the RTC had sufficiently explained the grounds for the denial of the motion. The petitioners moved for reconsideration. The Court of Appeals denied the motion in its resolution of April 17, 2008, hence the present petition.
At kahit na-deny ng Court of Appeals ang petisyon ni na Joey M. Pistillos, di sila nawala ng pag-asa at inakyat nila ito sa Korte Suprema. At ayon sa Korte Suprema,
it is unfortunate that the kind of motion that the petitioners filed has to reach this court for its resolution. The thought is very tempting that the motion was employed simply to delay the proceedings and that the use of Rule 65 petition has been abused. We find the petition unmeritorious and thus uphold the RTC order. The criminal proceedings against the petitioners should now proceed. In United States versus Snyder, the United States Supreme Court held that this constitutional provision does not prohibit arrest, searches, and seizures without judicial warrant, but only those that are unreasonable. With regard to an arrest, it is considered a seizure which must also satisfy the test of reasonableness. In our jurisdiction, early rulings of the court have acknowledged the validity of warrantless arrest. The court based these rulings on the common law of America and England that, according to the court, were not different from the Spanish laws. These court rulings likewise justified warrantless arrest based on the provisions of separate laws then existing in the Philippines. These rules were subsequently established and incorporated in our rules of court and jurisprudence. Presently, the requirements of a warrantless arrest are now summarized in Rule 113, Section 5, which states that arrest without a warrant when lawful. A peace officer or a private person may, without a warrant, arrest a person first when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Second, when an offense has just been committed and he has a probable cause based on personal knowledge of facts or circumstances that to believe person to be arrested has committed it, and when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped from being transferred from one confinement to another. A warrantless arrest under the circumstances contemplated under Section 5A above has been denominated as one in flagrante delicto, while that under Section 5B has been described as a hot pursuit arrest. For purposes of this case, we shall focus on Section 5B, the provision applicable in the present case. This provision has undergone changes through years, not just in its phraseology but also in its interpretation in our jurisprudence.
According to the court's ruling, Section 5B, Rule 113 of the Revised Rules of Criminal Procedure provides that first, an offense has just been committed. Second, the arresting officer has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. The elements of probable cause. First element, The existence of probable cause is now the objectifier or the determinant on how the arresting officer shall proceed on the facts and circumstances within his personal knowledge for purposes of determining whether the person to be arrested has committed the crime. The purpose of a preliminary investigation or PI is to determine whether a crime has been committed and whether there is probable cause to believe that the accused is guilty of the crime and should be held for trial. Probable cause in judicial proceedings for the issuance of a warrant of arrest is defined as the existence of such facts and circumstances that would lead a reasonably discreet and prudent person to believe that an offense has been committed by the person sought to be arrested. The judge must be satisfied that based on the evidence submitted, there is sufficient proof that a crime has been committed and that the person to be arrested is probably guilty thereof. It is sufficient that he personally evaluates the evidence in determining probable cause to issue a warrant of arrest. Second and third elements. The crime has just been committed, or personal knowledge of facts or circumstances that the person to be arrested has committed it. Personal knowledge of facts or circumstances. The phrase covers facts or, in the alternative, circumstances that are attendant or accompanying facts, events, or conditions. Circumstances may pertain to events or actions within the actual perception, personal evaluation, or observation of the police officer at the scene of the crime. If the police officer can make a warrantless arrest if, based on his personal evaluation of the circumstances at the scene of the crime, he could determine the existence of probable cause that the person sought to be arrested has committed the crime. The determination of probable cause and the gathering of facts or circumstances should be made immediately after the commission of the crime in order to comply with the element of immediacy. Immediacy means the time gap from the commission of the crime to the arrest widens. The pieces of information gathered are prone to become contaminated and subjected to external factors, interpretations, and hearsay.
Application of Section 5B, Rule 113 of the Revised Rules of Criminal Procedure. Requirements set under Section 5B, Rule 113 of the Revised Rules of Criminal Procedure. Number 1. Requirements of immediacy. Record shows that soon after the report of the incident occurred, SPO1 Monsalve immediately dispatched the arresting officer, SPO2 Javier, to render the personal assistance to the victim. The police immediately responded and had personal knowledge that a crime had been committed. Number 2. Police officers' personal knowledge of facts or circumstances. Personal knowledge of crime just committed under the terms of the above-cited provision does not require actual presence at the scene while a crime was being committed. It is enough that evidence of the recent commission of the crime is patent and the police officer has probable cause to believe, based on personal knowledge of facts or circumstances, that a person to be arrested has recently committed the crime. Number 3. The property of the determination of probable cause that a person sought to be arrested committed the crime. Considering the circumstances of the stabbing, particularly the locality where it took place, its occasion, the personal circumstances of the parties, and the immediate on-the-spot investigation that took place, the immediate and warrantless arrests, the perpetrators were proper. Consequently, the inquest proceeding that the city prosecutor conducted was appropriate under the circumstances.
Number 4. The term invited in the affidavit of arrest is construed to mean as an authoritative command. After the resolution of the validity of the warrantless arrest, the discussion of the petitioner's second issue is largely academic. The application of actual force, manual touching of the body, physical restraint, or a formal declaration of arrest is not required. it is enough that there be an intention on the part of one of the parties to arrest the other and the intent of the other to submit under the belief and impression that submission is necessary. Notwithstanding the term invited in affidavit of arrest, SPO2 Javier could not but have the intention of arresting the petitioners following Attorney Generoso's account. SPO2 Javier did not need to apply violent physical restraint when a simple directive to the petitioners to follow him to the police station would produce a similar effect. In other words, the application of actual force would only be an alternative if the petitioners had exhibit resistance. Number 5. The order denying the motion for preliminary investigation is valid. In their last-ditch attempt at avoidance, the petitioners attacked the RTC order denying the petitioners' urgent motion for regular preliminary investigation for allegedly having been issued in violation of Article 8, Section 14 of 1987 Constitution and Rule 16, Section 3 of the Revised Rules of Court. The RTC, in its order dismissing the motion, clearly states that the court is not persuaded by the evidentiary nature of the allegations in the said motion of the accused. Aside from lack of clear and convincing proof, the court, in the exercise of its sound discretion on the matter, is legally bound to pursue and hereby gives preference to the speedy disposition of the case. The RTC, in resolving the motion, is not required to state all the facts found in the record of the case. Additionally, no less than the Constitution itself provides that it is the decision that should state clearly and distinctly the facts and the law on which it is based. The petition denied. The decision dated January 21, 2008. The resolution dated April 17, 2008 of the Court of Appeals affirmed, and the City Prosecutor of Quezon City ordered to proceed with the criminal proceedings against the petitioners.
Matapos makamit ang hustisya, tahimik na ngayong namumuhay si Attorney Generoso habang masayang nagsiservisyo sa kanyang mga kliyente